Like you, I've not read through one of these couple 100-page leases. I have a lot of questions about liability, who's responsible for what when there's drainage. Is it the lessor, the lessee? Talk to me about chemicals and water table and water rights and everything else. These leases are absolutely incredible. They should be read by an attorney. When you get some of these documents, it's hard to understand. And so one of the people that we brought in today is an expert in the solar leases who's read these things and fought at the county and state levels and won. So I'd like to introduce to the stage Lorene, who's going to be able to spend a little bit of time with us helping unpack some of the intricacies and better understanding solar leases. Thank you, Lorene.
Hey folks, how are you? So since I have my PowerPoint presentation, I'm not going to wander around like the boys did, okay?
Can you hear her in the back?
No.
Okay, let me see if I can find somebody to turn that.
To turn it up?
I'm not in the back.
Yeah, I can't go like this the whole time, so. Let's see if I have the coordination to do this. So the first slide here, it just has my contact information. If you have questions after this that you don't get to ask, or in the future, you can feel free to email me, call me, text me, whatever you would like to do. You can ask anybody. I'm happy to answer your questions and just have a conversation with you. None of the people that come to me and say, hey, here's the questions that I have. Do I have a case? Is this a problem? They don't get charged up front for that. It's not until they sign on with me that the charges start to flow. So if you feel like you have a question and you want to call me, don't worry about that piece of it. You can absolutely call and ask some questions, and no one's gonna be sending you a bill, okay? So the first thing that I want to chat with you guys about is local zoning. So in Indiana Code 3613 is our home rule statute, okay? The policy of the state is to grant units all the power that they need for the effective operation of government as to local affairs. So that means anything not controlled by Indiana state statute, our counties have the ability to put that into statute ordinances here in our county. So think about your local zoning ordinances. Those are all home rule ordinances. Renewable energy and solar wind regulations, the Indiana General Assembly adopted a default standard for wind power devices and for commercial solar energy. And I've just put up, the very, very top where it has all the information here. You can read through those ordinances. It's 8141 and 8142. The standards for wind and solar are purely voluntary, and communities can adopt these local ordinances that they've made, or they can make more restrictive ordinances that are set forth in the two statutes that you see. I wanted to kind of tell you, in case you don't know, what your planning commission and BZA and commissioners do and what their role is when you're talking about solar ordinances and adopting solar and having solar come into your counties. So the primary duty of the planning commission is to develop and recommend to the legislative body a plan for the future of the community. When I say legislative body, that's because some counties are set up in a different way. So most Indiana counties have a planning commission, and the legislative body is going to be those three commissioners. There are some Indiana counties, though, where their legislative body is their council. It's kind of odd, I know. St. Joseph County is that way, so when we think about adopting ordinances and voting on those, instead of having their commissioners vote on those, it actually goes to their county council, and their county council votes on that. So I know it seems like every county should be set up the same way, but not every county is set up the same way. So when I say legislative body, that's why. Think for Huntington County, think your commissioners, okay? So unfortunately, very few planning commissions succeed in in making their overall plan the top priority. There's a lot of pressure from property owners and developers to take the commission's attention, and they spend most of their time making recommendations on zoning requests and decisions on subdivision proposals. If you've ever been to a planning commission meeting, I'm sure that you've seen rezone, zoning requests, requests for PUDs, requests to do a subdivision. Many commissioners also find it difficult to adhere to their comprehensive plan when they are confronted with a hearing room full of people advocating for a position that is inconsistent with the plan. Keep in mind, and you'll see a little bit here in this presentation, they are supposed to be following your comprehensive plan. Without your comprehensive plan, there is no zoning ordinance. It has to come first. And so when you think about your zoning ordinance, one of the things that they are supposed to be looking at when they think, do we need to rezone a property? Do we need to give a special use permit, a variance? They're supposed to look to your comprehensive plan and see what your comprehensive plan has to say about that. And let me say this, most comprehensive plans that I've seen in Indiana have within the first 2 items that they want to protect farmland. Farmland is very important in all of the counties that I'm in. And it's in their comprehensive plan how important it is. These plans are made by outside firms. They come in and they ask questions to people in the county. They do surveys and they talk to regular people in the county and they hold meetings and they find out what the citizens really want. They're not just talking to government officials. They're talking to the citizenry of the county. And then after they have that information, they set forth to put together a comprehensive plan. And usually they put together a top 5 or top 10 things that the county cares about. And I guarantee you, within the first couple of items, protection of farmland across every single comprehensive plan that I have seen. So it's interesting to me how you reconcile protection of farmland when they're then trying to take away large swaths of that for permanent land use change and change it over to solar. So that's the duties of the Planning Commission. We're going to talk about the duties of the Board of Zoning Appeals. And so you'll have a Planning Commission, I'm assuming 7 to 9 members on your Planning Commission. And then you have a Board of Zoning Appeals, 5 members on your BZA. The duties of the Board of Zoning Appeals are under 36.74901, and they fall into 3 categories. Your BZA is going to grant variances for things like development standards or uses. They're going to grant special use exceptions and conditional uses for property, and they're going to handle administrative appeals. So the BZA is the local government body that is empowered by the state to consider granting relief from the requirements of the zoning ordinance. The BZA is considered an administrative board that is quasi-judicial in nature. A quasi-judicial entity operates more like a court than a legislative body and uses many standards and procedures like the courts. BZA's decisions are required by state law to be guided by specific criteria and are made based upon facts and opinions. The primary role of the BZA is to rule on the application of existing zoning laws as opposed to passing new laws, and therefore it is considered an administrative body. So if you have something in front of your BZA, what are those things that they have to consider? So for a use variance, for instance, they would need to consider whether the approval is injurious to the health, safety, morals, and general welfare of your community, whether the use value is adjacent to property, including the variance will be affected in a substantially adverse manner. The need for the variance arises from some condition particular to the property. The strict application of the terms of the zoning ordinance will constitute an unnecessary hardship if applied to the property for which the variance is sought, and that the approval does not interfere substantially with the comprehensive plan. Look at that. A comprehensive plan came right up, didn't it? I can guarantee you, if you look at your comprehensive plan, unless they have just redone it, there is nothing about solar in your comprehensive plan. There's nothing about wind in your comprehensive plan. There's nothing about battery energy storage or carbon capture, because those aren't things that they probably thought of when they went through and did your comprehensive plan 5, 10, 15 years ago when they came up with it. So what can your county do to protect the citizens of your county? Well, the first thing that they can do is to review your ordinances, and if you're from Huntington County, your people are on top of this. I know that we have people from outside of Huntington County here, but that's exactly what they are doing. They have looked at the solar ordinances, and they have placed the moratorium, they've done number 2, on development under the ordinance that you want to strengthen or change. So when you place the moratorium, you're not placing it on the entirety of the zoning ordinance, just whatever specific development you want to strengthen or change in the ordinance. So you would place a moratorium on solar development, for instance, or you'd place a moratorium on carbon capture, or on battery energy storage. You would pick one. You could pick several, I guess. Put a committee together and gain information, review studies, and discuss alternate language. Once again, same thing that Huntington is doing right now. And then get help. And when I say get help, I mean talk to other counties, find out the language that has worked for them, that people have been able to agree to, and that their attorneys have said are not going to get them in trouble in their county. Talk to the current county attorney. Make sure that that county attorney has seen that language, understands that language. Have conversations with that attorney to make sure that you understand the language. And then find outside legal counsel. Typically, your county attorney will be helpful to you. If you're not finding that you can get information from the county attorney, or that he or she is helpful to you, then ask somebody outside of your county. So when we're looking at changing language in an ordinance, what kinds of things should we be considering? What should we be looking at? We should be looking at the comprehensive plan, the current conditions and character and structure of each of the use districts, what the most desirable use for the district is, the conservation of property values throughout the jurisdiction, and responsible growth and development. So review those ordinances, take a good look at your county ordinances and see that they really protect all property owners in your county. The renewable energy sector is fast moving, with more and more technology coming to our counties. Remember to place moratoriums on development and allow time to properly review language and appropriately protect the health, safety, general welfare, and property values. Put together committees and officials in your county. There are lots of people that live in your counties that have expertise and can assist you in these areas. Finally, get help from other counties, and we just talked about that. In 2022, the Purdue Extension drafted a document entitled County Zoning Ordinances for Commercial Solar Compared to Indiana's Solar Energy Ready Community Standards. They don't know how to have a short. So at any rate, this is the document they put together. The Indiana statutory language, it lays out 9 criteria for the solar ordinance. Setback height and buffer is under 1, ground cover is under another, fencing, underground cables and above ground infrastructure, glare minimization, signal interference, sound level limitations, drainage repair, and decommissioning, abandonment, and force majeure. So when they put together this document, which I think is about a 15-page total document, this is one of the graphs that they have inside the document, and they took each county and they said, well, how many of those areas is in that county's ordinance right now? So if you look, Putnam County has 10 of those in their ordinance. Ripley has 10 of those in its ordinance. Huntington County is at 5. So hopefully the work that your people are doing in Huntington County will get this number to all 9 of them. So this slide lists some additional standards that communities have added. Other less common standards include construction standards like dust and control and waste management, topsoil preservation, and design standards for driveways and emergency access. So you can see over here, they've also listed this table where, you know, the ordinances are saying you need to have warning signs or buffer yards, transportation agreements, proof of liability insurance, emergency and safety plans. If there are people in this room that have went over ordinances from other counties, I'm sure you've seen some of these. Economic development agreements, erosion control plans, landscape screening plans, property value guarantees, environmental analysis, and construction bonds are some of the, in 2022, less frequently incorporated additional requirements. I believe since 2022, we're seeing a lot more of those items come into our ordinances as people push for those changes. So how does this happen? Say I'm upset and I want my county to enact a moratorium. What are they doing over there? They're just letting solar run all over them and all these other renewables. How do I get them to do this? Well, generally speaking, the passing of a zoning moratorium has the same restrictions as a rezone. So it requires your county to provide notice, a public hearing, and then approval by your legislative body. So once again, not all counties are the same. So this information, and it says at the bottom, this is a general overview. If you want specific information for your county, the statutory language is under 3674-600. For most Indiana counties, the process would be to begin at the Planning Commission, and the Planning Commission will provide notice and hold a public hearing, just like if your neighbor was going to rezone their property. The Planning Commission then provides a favorable, unfavorable, or neutral recommendation to the county commissioners, and then the county commissioners provide their own notice and hold a vote on the passing of the ordinance to enact the moratorium. That's normal procedure in most counties and how it would operate. That doesn't mean that that's what happened in your county. Keep in mind, like, information provided an overview of the process of enacting the moratorium. Several factors may play into your county's moratorium, including whether there's already a moratorium in place and they just need to extend the moratorium. The moratorium can also be enacted on other types of development. I know that the focus is on solar development, but battery energy storage systems, carbon capture, wind, nuclear energy. If you believe that decisions made by your Planning Commission or Zoning Board of Appeals were made without reasonable regard to the evidence, you can challenge those determinations in court. There are strict time limits for this type of appeal, and your success rate is very dependent on facts and evidence presented at the hearings. Citizens all over Indiana are finding their way to local government meetings to have their voices heard. The one thing that you as a citizen can do is to show up. Show up and speak, write a letter, make your voice heard. In addition to making yourself feel better by getting it off your chest, when you speak at a Planning Commission meeting, BZA, or County Commissioner's hearing, you are creating a record. A good record in these hearings is invaluable. When a lawsuit is filed on the basis of the BZA's determination, that record is what the court will review, and only that record. So what if you think one of your Planning Commission members or one of your BZA members or one of your commissioners has a conflict? Well, here's the statutory language for you. 3674-223 states, the member of a Planning Commission or legislative body is disqualified and may not participate as a member of the Planning Commission or legislative body in a hearing recommendation of that commission or body concerning a legislative act as described in section 1016 of this chapter, in which the member has a direct or indirect financial interest. The commissioner body shall enter into its record the fact that its member has such a disqualification. Is very, very important. If you know that one of the members of your planning commission has a financial interest in a project, that you bring it up. You have to make that objection. If they're not going to do it themselves, you have to stand there and make that objection yourself. Once again, remember, most important thing is for you to create a record. That's the record that's going to go in front of a court. So stand there, don't feel bad about it. I know they make you feel bad when you stand up there. I've seen people apologize for taking a long time or for even speaking to their own public officials. I understand that most people that get up there are not public speakers, but do not feel bad about standing up for your property rights. What about the Board of Zoning Appeals? What about them and the conflict there? A Board of Zoning Appeals is disqualified and may not participate in a hearing or decision of that board concerning a zoning matter if the member is biased or prejudiced or otherwise unable to be impartial. So we have a little bit of a higher standard here. It's not just a financial interest. There's more. Has a direct or indirect financial interest in the outcome of the hearing or decision. The board shall enter into its records the fact that the regular member has a disqualification and name an alternate, if any, who participates in the hearing or decision in place of that regular member. We talked a little bit, can a commissioner have a conflict of interest? Well, Marshall County thought that their commissioner did, and they have filed suit against him. He had an interest in a battery energy storage project that was happening and continued to vote on all manner of solar ordinances and information. So this is what you want to hear about, right? You have a lawyer here, you want to hear about lawsuits. But what about my property rights? I have property rights. If you have ever been to a solar meeting and you've ever seen those people from the Pro Solar there, and they have their buttons, and it's all about their property rights, right? I have property rights. I can do whatever I want on my property. Can you really do whatever you want on your property? Although landowners generally may do what they please with their land, there are limits on absolute ownership. Landowners are prohibited from using their property in a fashion that may injure their neighbors. Ownership of land extends from the sky to the lowest depths of the earth. The law holds property ownership in a very high regard. Just as a property owner possesses rights to use his property, he also holds rights to prevent others from using their land in a manner that harms his property. So when you see that type of behavior at Board of Zoning Appeals and Planning Commission meetings, property rights, property rights, property rights, what they've forgotten about is your property rights. They're only thinking of the property rights of those who have signed a solar lease. They've forgotten completely about the neighbor who did not. So what can you do? What can you do if there's going to be solar panels right next to your house? Well, potentially you could file a nuisance or a negligence action. Under 32-36-6, a nuisance is defined as whatever is injurious to health, indecent, offensive to the senses, and any obstruction to the free use of property. So as essentially to interfere with the comfort, enjoyment of life or property is a nuisance and the subject of an action. So the nuisance describes a situation in which one landowner is using his property in a way that unreasonably limits the use of the neighbor's land. Property owners can be liable for nuisance that originate from their property. This is true even if someone else is creating the nuisance. So say that I have a nuisance. Say that Denise put solar on her land, and now I'm her neighbor, and it's making all kinds of noise over there, and there's a whole bunch of runoff from where they did all this construction. What can I do? Well, you can recover damages for this nuisance. You can file for injunctive relief and make it stop, make them fix things. You can get compensatory damages. You can get potential future damages. If the nuisance is causing you some kind of a physical or mental ailment, you might be able to get medical bills and attorney's fees. All this recovery is very fact dependent and is controlled by the damages that the plaintiff can show. So for instance, if the plaintiff can show some type of physical or mental injury, the medical bills may be recovered. What about your property value? Studies show that industrial solar will decrease your property value. I believe the last study from Mary McClinton Clay, and I know Denise is going to go into this much farther for you, said that your property value would be reduced by approximately 30%. If your house is surrounded by solar, I took a call just this week from somebody who told me that there was a gentleman in their county, the house was surrounded by solar, he tried to sell it for a year, couldn't sell his house. A diminution in property value refers to a decrease in the market value of the property. If a renewable energy developer is purchasing the land adjacent to your property, it's important to get your property assessed immediately, prior to any development. This information can later be used to show a decrease in your property value due to the renewable energy development. For those people living in counties without property value guarantees, if solar is coming in near you, have someone do an assessment on your property. If you at a later time try and sell your property and it's far below market value, that assessment is going to save you, because you will know how much it was before solar came in, and absent any other factors, it can be attributed to the solar. So what about solar leases? Some of our friends and neighbors have signed solar leases, right? I think that a lot of people get the wool pulled over their eyes. I think that solar developers and solar salespeople that come to the doors are not always honest with people when they speak to them. I've seen these solar leases. They are hard for me to go through. I can't imagine someone standing at a door with 40 pages of a solar lease saying, here, I have the guy who's going to notarize it for you right here. All you got to do is sign. So in general, and there is far more to a solar lease than this, but we're being very general today. You're going to get the lease terms or the payment amount right up front. That's on the first page always, every time. You're going to get what property is going to be encumbered by the lease, the liability of the landowner, and what kind of damage will be to the property of the landowner. So why do property owners even sign these solar leases? Well, because there's money. Commencing on the effective date of this lease and continuing throughout the term, tenant shall pay to landlord an annual rent payment equal to $1,000 per acre of the site, escalating annually at a rate of 1%. This gets confusing for people. So they say, I have 100 acres, and you can have the 100 acres. Go ahead, it's your solar company, you can have it. And the solar company says, great, thank you so much. And they sign the lease. Well, the solar company is only going to pay them on the acreage that they use. So while they had 100 acres and they told solar they could use 100 acres, maybe they only want 20. So they're not getting as big of a payday as they think that they're getting. Let's talk about what they're going to encumber though. They're only going to use 20 acres of the property, but they're going to encumber all of it. When the solar company while the solar company may represent to you that they only want a small piece of your property, the lease you sign will likely provide them with the rights to all of your land. The solar representative will be able to enter your property 24/7. The lease gives the solar company permission to put any of their equipment on your land. So when they come to someone with a solar lease, they might say, hey, we just really want to put a wire underneath this part of your property. That's all we want to do. And here it is. We just want to encumber the entirety of your 100 acres though, but this is all that we want to do. But then plans change because other people didn't sign the leases, that they thought were gonna sign the leases, so now they gotta change some stuff up. So now they're gonna put solar arrays all the way across your property, because they can. The lease says that they can, it allows them to do that. And there's, aside from fighting it in a court, which if you're signing a solar lease because you want that $1,000 an acre, you probably don't have a whole lot of money to be fighting legal battles. You're letting them put solar arrays on your land now. What about access to your land? This is from a solar lease that we have. Tenants shall have the right from time to time during the term of this lease to determine the feasibility of solar energy power production on the site, including studies of sunlight concentration and other meteorological data, extracting soil samples, conducting wildlife and other environmental studies, and conducting transmission feasibility studies. To construct, install, reinstall, or relocate and operate the generating facility on site. To maintain, clean, repair, replace, dispose of the generating facility. To add or remove equipment as needed to increase or decrease the capacity of the generating facility. To remove the generating facility as permitted as Section 9. To access the site with guests for promotional purposes during normal operating hours or other times that are acceptable to the landlord in its reasonable business judgment without disruption of the landlord's operations. They can do whatever they want. When can the solar company enter? Landlord will make available to tenant continuous and uninterrupted access to the generating facility and the site and the easement lands for the purposes set forth in the lease. Tenant shall cooperate with landlord to minimize disruption of operations and landlord at the property. Despite anything to the contrary in this lease, tenant shall be permitted to access the site and easement lands 24 hours a day, 7 days a week. But we know they can come on your land anytime they want, right? What about if something happens? What about if something breaks or a fire starts or your neighbor's upset and they want to file one of those nuisance actions against you? What kind of liability do you have if you've signed a solar lease? Solar leases may require landowners to accept liability for things like noise, flicker, glare, electromagnetic radiation, and health problems. So here, if you look at the bottom, is a direct copy and paste from the Idlewild lease. Idlewild is the project that was going in Jefferson County. Noise, glare, and shadow. Leasee shall have the right in connection with the construction, use, and operation of facilities to admit or cause the emission of noise to impact the owner's views of and from the property, to allow or permit the solar facilities to cast shadows, and to create, cause, emit glare or shadow onto the property and adjacent properties or similar field effects. Owner, for itself and on behalf of its successors and assigns, hereby accepts such effects, waives any right to object to such effects, and releases the lessee from any claims, damages, or liabilities or losses that the owner may incur therefrom. Let's talk a little bit about what indemnification is. So indemnification, also referred to as indemnity, is the undertaking by one party, the indemnifying party, to compensate the other party, the indemnified party, for certain costs and expenses, typically stemming from third-party claims. Indemnification can also cover direct damages, which are claims or causes of action that one contracting party has against another. So why are we talking about indemnification? Lorraine, why did you give us that definition? Well, because the solar lease has a portion that also talks about indemnification. Each party agrees to defend, indemnify, and hold harmless the other party, and the other party's officers, directors, shareholders, members, managers, employees, representatives, mortgagees, and agents against any and all losses, damages, expenses, and liabilities for physical damage to the property or for physical injury to any person including activities of the indemnifying party on the site or easement of lands. Now, what do you think? Do you think that this is for the property owner? You think they're gonna hurt the solar company while they're out on the site? Is that, no. No. This is making sure that the solar company is indemnified, that the person who owns the property, that their property insurance, should something happen, is gonna get a claim. And it's gonna say, oh, there's this indemnity clause here in our contract. So guess what, State Farm? Guess what, Hanover, whoever your property insurer is, right? Shelter. Guess what? Here's a claim for this injury that I've caused to my neighbor. But I didn't cause it. The solar panels caused it, but I have to indemnify them. Damages caused by solar. Solar companies place language in contracts that allows them to terminate the agreement at any time without cause, cutting off that income that they promised for 30 years. They also have information in here with regards to surface damages. The parties anticipate and acknowledge that landowner may suffer damages to crops, grass, fences, and other property improvements on the property during tenant's construction, installation, decommissioning, relocation, and maintenance of the generating facility on site. Tenant shall pay landlord fair compensation for any such losses or damages, and if the parties can't reach an agreement to the amount that would constitute fair compensation, the issue shall be submitted to arbitration. You know what that means? If I have a solar lease and I have damages, and I say to the solar company, I have damages, and they say, we'll give you $1. And I say, that's not enough. And they say, well, I'm sorry, we'll give you $1, or we can go to arbitration. Not to court. You don't get to sue them. You get to go to arbitration instead. A breach of contract occurs whenever a party who entered into a contract fails to perform their promised obligations. Let's talk a little bit about, you say, well, you know what? I would never sign a solar lease, so I'm fine. But my neighbor, he signed a solar lease. So what is solar going to do now? Well, they're going to come by and they're going to say, hey, how's it going? What do you think about signing this good neighbor agreement? We're going to give you we're not going to put any solar on your property. You wouldn't sign that agreement. But if you sign this good neighbor agreement, it'll be an agreement between the two of us, and I'll give you some compensation for it. In this case, it was consideration of $2,000 up front and then a one-time payment of $15,000. And I'll represent, this good neighbor agreement is from Wisconsin. I'm just giving you some regular language, okay? Well, what do you have to give away for this $17,000 that they're giving you? Cooperation. Owner shall fully support and cooperate with Western Mustang's development, construction, and operation of the project, including in Western Mustang's efforts to obtain any governmental authority or any other person or entity, any environmental impact review, permit, entitlement, approval, authorization, or other rights necessary or convenient in connection with the project, without limiting the generality of the foregoing in connection with any application by Western Mustang for a governmental permit, approval, authorization, entitlement, or other consent related to the project. Owner agrees not to oppose in any way, whether directly or indirectly, any such application or approval at any administrative, judicial, or legislative level. So you can't go to the BZA and complain. You can't go to the Planning Commission. You can't go talk to your commissioners about this anymore. So let's just talk a little bit about some of the pending lawsuits currently in Indiana for solar. And I know Denise will have more information about this because she was really right there in the middle of some of the lawsuit stuff. So this is Madison County, where Denise and I are from. Citizens Fight Back. This is a picture of everybody in their red no solar shirts at, I think that's a BZA meeting. So initially the BZA in Madison County, they were going to let Lone Oak Solar come into the county. They approved it. They said, that's fine, we're good. And they said, Lone Oak, you got 3 years to build. 3 years, have a good time, we'll see you back, right? Well, because of some complete shadiness during the BZA hearings and some conflicts of interest that occurred, the citizens of Madison County filed suit. They filed suit in court, and Denise, did that one get changed outside of Madison County right away?
No,
Okay,
it stayed local.
so that one stayed local. They lost in state court. They appealed it. They were like, we don't trust this. It was in Madison County, right? We're taking this and we're gonna appeal it. So they appeal it to the appellate court. And they lost in the appellate court. But while this was all happening, time just ticked on. And when they lost in the appellate court, they said, we still don't think that the court is right, so we are gonna go ahead and we're gonna appeal it to the Supreme Court. So they requested cert to appeal to the Supreme Court, and the Supreme Court said, no, you're not gonna be able to appeal it here. So the remonstrators of Madison County felt defeated, but as time ticked along, Lone Oak wasn't doing anything. It hadn't started any construction. It wasn't making any additional commitments. So about the middle of 2023, Lone Oak comes back in front of the Board of Zoning Appeals, and it says, maybe it was 22, no, it was 23.
June 2022.
Yeah, June of 2022. They come back in front of the Board of Zoning Appeals and they say, hey, we're gonna need some more time. And the BZA says, what do you mean? You had 3 years, what are you guys doing? And they said, well, you know, COVID happened, and there were supply chain issues. We couldn't get the stuff that we needed. And you know what else? Those stinking NIMBY neighbors over there, they sued us. They sued us and we couldn't get a loan. Now, those stinking NIMBY neighbors didn't sue them just so they didn't know that was gonna happen, right? They were just upset and they wanted to file suit. They believed that things had happened in that BZA hearing that were not right. And they wanted to make their voices heard. They wanted to file a lawsuit about that, and they did. And the unintended consequence of that fight that they had was that Lone Oak Solar couldn't get a loan. Couldn't get a loan for the project. They had no idea until Lone Oak stood there and said that. So by this time, Denise had been providing a lot of education to a lot of people, and some of the boards had changed in Madison County. And when they stood there in front of the BZA and they made these arguments that they just couldn't even get a shovel in the ground in the 2.5 years, the BZA said, we're not inclined to give you any more time. We gave you a deadline. That is your deadline. Lone Oak didn't like that, so they filed with state court, and that now is still hanging out in Grant County. And then they also filed with the IURC. So what are they trying to do when they're filing with the IURC and they're saying, oh, well, we don't think that these local governments should have any control over this development at all. Even though we signed a document saying it was totally cool and they could have control over it, we would like to take that back right now, and we don't think that they should. I think they want to be like a governmental utility. They want to be able to do what they say that they can do when they come to your door and they say, we're going to take your land by eminent domain. They don't have that power, but they want it really bad. So the IURC judge said, no, you made your bed, you got to lie in it, you signed this document, you said that you wanted them to have local control, they have local control, you have to go and do what they tell you to do. You don't get to come back and take backsies. No, this is what's happening. And they didn't like that. So they filed with the Court of Appeals, and the Court of Appeals agreed with the IURC judge. Denise and I sat together at a table and worked really hard on an amicus brief for that Court of Appeals opinion. And once again, unintended consequences. During that Court of Appeals opinion, Lone Oak tried to make arguments that we basically had colluded with the county to put in additional information, that they were behind us NIMBY neighbors so they could introduce documents that weren't part of the record because we had filed this amicus brief. And they got shot down pretty hard by the court with that, and by Kevin Koontz, who did an amazing job responding to those motions. And I said to Denise after I read that, I said, "Oh boy, they essentially misrepresented to the court a few things." And the court said, "Nope, that is all denied." And Kevin said, "You don't have any evidence for that. Why are you making these arguments?" And I think that looked pretty badly for them at the end of the day. And so the Court of Appeals denied their appeal and said, "Sorry, IURC's determination stands." Oh, I thought there was one more slide. Sorry guys, I thought there was one more with regards to the Supreme Court decision. So, not being one to give up, Lone Oak has filed for cert to the Indiana Supreme Court to hear an appeal there. There's been briefs back and forth, and we have really right now no answer as to whether the Supreme Court will pick it up. Keep in mind, the Indiana Supreme Court only takes a small portion, less than 10% of the cases that are sent up to it. So I would say it's probably pretty risky for them. I would say that they probably won't get picked up, but they could get picked up. If they do, I think probably Denise and I will work together to try and put together some kind of amicus brief again, because you never know. I tell all the people that I work with, you have to fight. You have to fight at every step. You have to keep fighting, because you're going to be in a position like Madison County was with Lone Oak, where you're fighting and you don't even realize that you're bothering them in another way, right? That you're stopping them from getting a loan. You don't even realize that they're going to make some ridiculous argument about how you were working with the county, and it's going to make them look so terrible because they misrepresented information to the court. So I think it's important for everyone, and you're all here, so that's amazing. I think it's important for everyone to stay engaged, and I think it's important for everyone to stay fighting. I will say Jefferson County denied, their BZA denied the permit for Idlewild Solar that they had. Idlewild has filed, they filed in Switzerland County, weirdly, but they filed an appeal to that BZA decision. So we'll see how that goes and where that goes through the court. Denise, do you know of anyone else right now that has an open appeal? Those are the only two I know of.
Isn't Pulaski County still fighting? And I do believe that Jason Cushman has a few other cases he's involved in, several. I know Spencer County is still in legal battle.
Is it local?
I have no clue where they're at.
So across the state, people are still fighting. So I encourage you all, whether it's at a drainage board meeting, at a planning commission meeting, at a board of zoning appeals meeting, at a commissioner's meeting, or if you need to take something to the court, I encourage you all to continue to fight, stand up and make your voice heard, make the record that you need to make, and don't give up, even when you feel like it might not be going so well. I mean, Denise, did you have a really bad feeling after all of that?
I can't even tell you how many times I've wanted to quit. I've had some big conversations with God, and it's brought me to my knees. It's tested my faith more than anything. But God's good, and I never stop. And I won't.
All right, so do you want to do questions just at the end? Okay.